Good morning. Are you Willie Edward Pugh Jr.? Give me just a second, Mr. Pugh, to get this pulled out. Mr. Pugh, in cause number 25, DCCR 1835, you're charged with a third-degree felony offense of unlawful possession of a firearm by a felon from October 23rd of 2025. The indictment alleges that you were previously convicted of the third-degree felony offense of unauthorized use of a motor vehicle, May 13th of 1996. 2 cases of that same offense on that same date. After those were final, you were convicted of the felony of unlawful possession of a firearm by a felon, February 20th of 2007. You were also convicted on that same date of possession of a controlled substance, a third-degree felony. After those were final, the indictment shows that you were convicted of evading arrest or detention with the use of a vehicle, April 15th of 2019. And on that same date, also possession of a controlled substance, a second-degree felony, and unlawful possession of a firearm by a felon, also on that same date. What that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be that of a habitual offender, which is a minimum of 25 years in prison, up to 99 years or life in prison. Do you understand?
Yes.
I have here on the tablet a plea bargain rejection that has your signature on it with Mr. Rojas that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty to go forward probably on, it looks like counts 1 and 2. That would make this a second-degree felony for a 14-year term in prison. You have every right to reject that. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty. And do you understand all of that?
Yes.
And do you want to reject that offer and have your case set for trial?
Yes.
Okay, I'll get that done. Ms. Malfino, is there any reason to believe that that offer would change? Any information you think you don't have at this point?
Judge, just to be candid with the court and not to give the defendant any false hope, I'd like to speak with the officer actually in person rather than the review of his report. There might be some question as to the validity of that search. I'll certainly bring that to the court's attention well prior to the trial docket. That would be the only reason after speaking with him that I would consider altering the offer with the court's permission. He's been before you, Judge, multiple times with 10 and 12-year sentences reasonable.
And
I
Judge,
could do that very quickly.
if you'd rather just reset a week or 2.
I would I would rather if you can get that done in 2 or 3 weeks, just to do a regular reset. That way we can all say with at least some certainty that the offer is what it is based on the evidence and based on your discussions, or if something changes, then we'll take care of it one way or the other. So let's do this. I'm going to delete that plea bargain rejection for now. I'll reset it for about 3 weeks. That'll give Ms. Malfino time to speak in person with that officer, get with Mr. Rojas. He'll get with you, let you know what the final discussions come out to, and then we will see where we get at that next court date. Okay, you can go back with the bailiff.
This might read different.
This is Mr. Coleman's Kaylin Thornton. Good morning, sir. Are you Kaylin Thornton? And will your client waive the formal reading of the indictment?
Yes, Your Honor.
The state's elected to proceed on the lesser included. Instead of the aggravated promotion of prostitution, the state's proceeding on a promotion of prostitution under 4303 of the Penal Code.
4303
of the Penal Code. It makes it a third degree as opposed to the first degree that the aggravated promotion of prostitution is.
Thank you. And will he waive the formal reading of the indictment as?
Yes, Your Honor.
All right. So Mr. Thornton, in cause number 26, DCCR 0220, the state's elected to proceed on the lesser included offense of a third degree felony promotion of prostitution from November 15th of 2025. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes.
And because you did what they've charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Holmes?
Yes.
Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that would be probated. You'd be on probation for 10 years. There would be a $1,000 fine. You would be required to follow all of the rules and conditions of probation, including remaining away from the Northridge Manor Apartments at 4155 Maida Road in Beaumont. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yeah.
State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Thornton's not
No,
competent?
Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you, your case, and then we'll come back later for sentence. Based on the nature of that plea agreement, Mr. Coleman, what's the state's position with regard to a bond pending or bond reduction pending pre-sentence report?
The defendant shows to be a 25-year-old with no criminal history. However, there are some circumstances related to the underlying offense. I don't know if the court is. There was some violence alleged with regard to the underlying offense. Just for the court's information, we would defer to the court on that, but I just want to make the court fully aware of kind of.
And Your Honor, we are asking if the court would consider a reduction. Mr. Thornton has no intention of returning to that property. He will.
Where would you be living when you're released, Mr. Thornton?
2118 Avenue B.
That's in Beaumont.
Yes, ma'am.
So what I'm going to do pending sentencing based on the nature of your plea agreement, Mr. Thornton, is reduce your bond in your case to $2,500. If you make that bond, at least pending sentencing, I'm going to order that you wear a GPS monitoring device. That'll make sure that you're following all of the rules. You're not going anywhere near
Maida.
the apartments, is it Northridge Manor?
Yes, ma'am.
Don't go anywhere near those. And if you do everything you're supposed to between now and sentencing, then I'm not necessarily saying you'll have to wear that while you're on probation or for very long. But if you make that bond while the case is pending, I want to make sure that you're following all of those rules. It's very important if you make that bond, a couple of things. In addition to getting that GPS and staying away from the Northridge apartments, you're going to get some documentation today from probation. If you are released soon, then the very first thing you do is go to probation so they can do that pre-sentence report. If you don't go and don't follow through with those appointments, then you run the risk of me not accepting the plea agreement. Things could be worse. Do you understand?
Yes.
Also, if you are arrested for anything between now and when you come back for sentencing, you run the risk of me not accepting the plea agreement. Okay?
Yes.
All right. You can go back with the bailiff.
Thank you.